Welcome, everyone, to the continuing New Jersey case law series. Today, I want to talk about a case called Hinton versus Acosta. And this is a case that was decided by the New Jersey Appellate Division. This case involves a motor vehicle accident that occurred between two individuals. And it's a warning that you have to be very careful what you propose and what you agree to after an accident, because a court will find an agreement, an oral agreement to settle a case after a motor vehicle accident to be enforceable. In this case, the plaintiff, Raven Hinton, got into a motor vehicle accident with the defendant, Acosta. Plaintiff was struck by Acosta's vehicle. Plaintiff, after the accident, approached the defendant, Acosta, and told Acosta that he wanted to settle the case for $500 at the scene. The police officer arrived at the scene and recorded these conversations and interactions between Hinton and Acosta on the body cam footage. Acosta, or rather Hinton, said to Acosta, "It's over with. I just want my $500 to just go right now." The defendant agreed to pay $400, which Hinton then agreed to, and both the plaintiff and defendant went to find an ATM where the defendant, Acosta, could withdraw the settlement money. They came back to the scene. The settlement money was paid to Hinton, and this was again recorded on the police officer's body camera footage. So after the car accident, after this agreement to settle took place, after Acosta paid the money to Hinton to settle the motor vehicle litigation, Hinton filed a lawsuit against Acosta. Acosta had an attorney, filed an answer to the lawsuit, and Acosta filed a motion for summary judgment. And Acosta basically told the court there was an enforceable settlement agreement in place, and therefore the lawsuit filed by Hinton should be dismissed by the court with prejudice. The trial court agreed with Acosta and said, yes, this is a valid agreement. There was a meeting of the minds. There was consideration transferred by way of the money, and this was a valid agreement, even though it was not in writing, and dismissed Hinton's lawsuit. Hinton then filed an appeal with the New Jersey Appellate Division. The Appellate Division affirmed the decision of the trial court dismissing Hinton's case. And the appellate court said that an agreement to settle a lawsuit is a contract, and like all contracts, it may be freely entered into, and which a court, absent a determination of fraud or other compelling circumstances, should honor and enforce as it does to other contracts. The court also said that courts should discern and implement the intentions of the parties and not rewrite or revise an agreement when the intent of the parties is clear. The court found that valid settlement agreement requires an offer and an acceptance by the parties, and the terms of the agreement must be sufficiently definite so that the performance to be rendered by each party can be ascertained with reasonable certainty. Hinton argued that he never accepted Acosta's offer, and he didn't have the capacity to enter into an agreement due to the surrounding circumstances. However, he provided no evidence in the record in his opposition to Acosta's motion to support that assertion. The court found that the footage showed the interactions between the parties and that the officer's body cam footage provided further evidence of the intent of the parties and supported finding that there was a valid settlement agreement in place. Hinton also said that Acosta had pressured him into entering into an agreement, and the court said no, there's no evidence of that, and that it was Hinton who approached Acosta to pursue a settlement of the accident case, not vice versa. Finally, Hinton cited to a statute, which is NJSA 17:29B-15. And this statute in general provides that if an insurance company tries to settle a case with an injured party within 30 days of the accident, that the agreement will not be enforceable unless the claimant, prior to signing a release or waiver, receives a written disclosure from the insurance company informing the claimant that he may seek legal representation, and further informing the claimant of his rights pursuant to the statute. And the appellate court in this case said, well, that statute doesn't apply because this agreement was between two private parties. It was not between a private party and an insurance company. Therefore, that statute was found by the appellate division to be inapplicable. So, in conclusion, the court found that there was a clear contract, there was a meeting of the minds, there was consideration exchanged, and that the plaintiff, Hinton, was barred from filing a personal injury lawsuit and dismissed his lawsuit for good. And it should be noted that in this case, Hinton claimed in the lawsuit he tried to file some serious injuries, including a traumatic brain injury, cervical spine injury, lumbar spine injury, and knee injury. We don't know whether those claims had the potential to get a recovery or not and compensation, but by entering into this agreement at the scene, Hinton waived his rights to pursue compensation for those injuries. So the lesson of the story is to be very careful what you agree to, because even though it may seem inconsequential at the time, even though it may be at the scene of the accident or some later time, if you enter into an agreement, even if it's an oral settlement agreement, the court will enforce it. Thank you for listening to this presentation. And again, my name is Matt Miner, and I'm an attorney with Gill and Chamas in Woodbridge, New Jersey. And if you want to reach out, my contact information is below. Thank you.